So this class is a continuation of unit interest in real estate. And so last class we spoke a lot about easement by prescriptions and easement by necessity and creating an easement and life estates. You know, we went into some international languages talking about per autre vie, right, and so forth. So today we're going to start off with terminating an easement. So basically, you know, the text outlines 1, 2, 3, 4, 5 ways in which an easement can be terminated, right? The first one is when the easement no longer exists, when the need for that easement no longer exists. So maybe somebody was using that particular trail in the back of your land because they had no other way to get to their property. And unless they were to drive 30 miles all the way around a mountain or something. But who knows, maybe somebody built another trail and they just don't need to use it anymore. Or when the owner of either the dominant or the servient tenement becomes the sole owner of both properties. So that could be an opportunity where, you know, somebody buys both properties and will merge them together, right? And so there's no longer a need to have an easement in that particular way. By the release of the right of easement to the owner of the servient tenement, by the abandonment of the easement, or by the, again, the non-use of it, of a prescriptive easement. So the whole point is that easements, they usually do run with the land most of the time, but not every single time, and sometimes they can be terminated. So does anyone have any questions on that? All right. Next section talks about licenses. So what is a license when we talk about, you know, for interest in real estate? What's a license?
It's a privilege to somebody else's land, but when they pass away or something like that, it ends.
Right. So remember, it's a privilege, like you said, to be able to enter the land for a specific reason and so forth. And so, like, think about it this way. It could be, right? It could be that you gave somebody a license to be able to fish on your land or be able to do bird watching on your land or and so forth. And so you have to be really careful about giving licenses because it's not just automatically that you can take it back so easy in some cases if you decide not to. Like, think about it this way. You know, right now things are a little bit different, so it might not have happened to you recently, but maybe you bought a ticket in the past to go to a concert or a movie or a baseball game and so forth. Now, if you just go there and mind your business, right, and sit down and do and relax and enjoy the show, can they come up to you and grab you and say, get the heck out of here, you shouldn't be here, or we're not going to let you watch this show anymore? No, because you bought a ticket and kind of that's technically your license to be there. Now, of course, if you went to the movies and you started throwing popcorn at people, right? I know some of you are laughing right now, but you know, I'm not throwing popcorn at people. They can kick you out for being unruly or behavior. But sometimes a license cannot just be terminated or canceled with the, you know, the snap of your fingers. So you have to be careful about giving people a license to your property, right? And again, a license is a little bit different than an easement because most of the time, or all the times that I know about, it's going to end after a certain period, maybe a certain season, maybe a certain date, or definitely usually with the death of either the party or with the sale of the land. Okay. Any questions on licenses? All right. What's an encroachment? Who knows? What's an encroachment?
When a building or a piece of property flows into your property.
Right. So, you know, that's when people meaning your neighbors or whatever it might be, start getting a little bit nervous. You know, like for example, one day I had a property that I was getting ready to put on the market, and I was over there talking to the young couple that was selling the property, and they were like, well, you know, we do have that shed in the backyard, and we put it there quite a few years ago, and it's technically a couple feet on that owner's land. And he said it was okay as long as we're living here, but once we leave, you know, he wants that shed to be moved. So, and that's going to be really hard for us to move. So we're not sure what we need, what we're going to have to do. And wouldn't you know, I put the home on the market, and the day that the sign was out there, who do you think called me? Is
The owner.
Yeah, the old man from the other piece of land. And he was like, hey, you know, they got their shed, they encroached on my land. I gave them permission to do it, but I just told them verbally that as soon as they move, that has to be moved. And, you know, like we said, usually it's disclosed. A lot of times people will, both parties will know, sometimes they won't, but it's basically illegally extending beyond the boundaries of the land, right? That's called an encroachment. Somebody tries to put a fence just a, you know, a foot or two on your land. And what are some of the things that you'll be able to do to stop that? What are some of the things that you'll be able to do to, you know, make sure that they don't actually try to take that land from you? All right. So that's basically an encroachment. Any questions on that?
Do trees and things fall under that description?
That's where it gets tricky with the whole world of airspace, right?
Okay.
So remember, whatever unit it was, I think unit 1 or 2, we talked about airspace. So you could have somebody that, you know, the fence is here, the tree is here, and here's the branches going over on your airspace, right?
Mm-hmm.
So of course you should be talking with an attorney, and of course you should maybe talk with the town. But everything I've ever read or heard or learned is that you own all this airspace right here, right? This is your land. You own this airspace. So if the tree was growing on your airspace, right, you should be able to cut the branches according to your boundaries.
And if the tree falls in my yard, then what?
Well, first of all, I want to make another statement, then we'll talk about that. Some neighbors will be very, very, very upset with you, but it's on your airspace, and if you don't want it, you technically should be able to cut it. Now, because it's kind of like an encroachment if you don't want it, and you tell them, hey, listen, you have to cut your branches, and they don't. Now, if the tree falls on your yard, that's when the wonderful world of what comes into play? Insurance, right? And who was responsible? Was it an act of nature? Did somebody make a mistake and cut it the wrong way? Was it dying for a long time? Did it fall on your house? Were there any
damages or anything?
Yeah, damage. Was there any correspondence between you and the neighbor that you've been telling them to cut that tree? So I just don't want to make a statement on that because I think there's like 100 variables, and I don't want to give you the wrong information. And I think it just really depends a lot on the situation.
If it falls in your yard, don't you technically now own it? Okay.
I guess, yeah. But I've heard people say, oh no, a tree fell on my yard, and my insurance company wouldn't give me anything. They said we had to go after their insurance company, and the town wouldn't help me. And, you know, I don't know. I honestly don't know all that stuff, because every time I hear a story from someone, it seems like it's different from the last person.
Okay.
You know, so yeah. All right. Any other questions on kind of encroachments or licenses or easements and so forth? So in the next section, you know, that they want you to know is they want you to be understanding of what the word or the term lis pendens means. So what is lis pendens? Who knows? What's lis pendens?
Pending litigation.
Right. And so what does that mean? Pending litigation. What does that mean?
Like a foreclosure.
Right? So remember, let's say somebody doesn't pay their mortgage, right? And they miss 2, 3, 4, 5 payments. Now, how many payments do they have to miss before the lender is going to start a lis pendens or a foreclosure action? Who knows?
It depends.
Hey, that's the person. It depends. That was Deidre, right? Yeah? All right. It depends because we don't know. I've heard some banks that somebody missed 2 payments, boom, they served the lis pendens, they were getting ready to start the foreclosure. And I've heard some lenders, I've heard some people, they're living in this house for 2.5, almost 3 years, haven't made 1 payment, and the foreclosure, they haven't even gone to court once yet. So it just totally depends on the situation, right? And what that lender's ready to do. But ultimately, when that lender or maybe that town, if you didn't pay your property taxes or so forth, is sick and tired that they haven't received payment, they are going to file in the public record a pending legal action, a lis pendens, litigation pending, saying, hey, right now we're taking legal action affecting the title to or possession of the property, right? And so that will basically kind of create, some type of cloud or, a recording on that deed, right? Or on that those records in the town hall, right? And so why do you think that that's usually the first step? Why is that important?
It's
Then you can't sell the house. It's kind of putting it out there. So if someone looks into it, it's showing. It's a record.
So to me, you're 80% correct, right? Can you sell the house?
you're giving the homeowner an opportunity to catch up with their debt as well.
Well, just remember, I just want to make it clear, you can still sell the property.
Do a
Right?
short sale.
Somebody with cash can come along and figure out a way to buy the property from you or to pay that off for you and so forth. So you can still sell. But the whole point is to give constructive knowledge, to give knowledge to other parties that to say, hey, be a little careful, be cautious if you're buying this property because there is litigation pending on it. Something will have to be resolved, usually before the transfer of the property. Or if you were to buy it anyways, you're going to be absorbing or you're going to be adopting those issues. Does that make sense?
So if you sold the property, say if the person was in arrears on their mortgage and the property sold at whatever the asking price was, the person buying the property is also on the hook for the arrearages. Is that what you're saying?
No, so that's why it gets tricky because remember, it doesn't always have to be a mortgage. It could be a
lien.
Yeah. So if it was a mortgage, right? Almost all mortgages, at least that I know of, they have a clause in those 40 pieces of paper that say, hey, in order for this property to transfer from one party to another, that has to be paid off. That has to be paid off, right?
Right.
But like, let's say it was, somebody got $30,000 worth of work done, siding and so forth on their house, and now they only paid the guy $2,000 or whatever, and they still owe $28,000, and so now this contractor has had enough of the baloney, and they start the foreclosure action in order to get their money, and so they serve lis pendens. You could actually buy the property and try to work out arrangements with that contractor. Right? Like I bought properties with liens on them. Right? It gets tricky, and it depends a lot on the timing of things and when they started the foreclosure action. Did they start it in time? And but you can buy properties with these types of liens and so forth on them. Make sense?
Yep.
But yeah, there's all different, again, that's another one, all different scenarios. Is it by a mortgage company, a lender? Is it a mechanic's lien? It is a vendor's lien? What kind of lien is it, right? All right, governmental powers. So they want you to know the acronym PEAT, right? The 4 governmental powers, right? And we know that, or we believe, you know, hey, when we buy this property, we own it and we can do whatever we want here. And we know that that's not really 100% true. There's a lot of governmental powers or limitations that are imposed for the general welfare of the community, and they supersede the rights or interests of the individual. So you can't say, hey, Rob Rosa told me that technically when I own this piece of land, I have the air rights up to the atmosphere. And so I don't want any planes flying over my land, right? Well, the governmental powers are going to give the FAA or NASA or the Space Force or whatever it is these days, and the Air Force, the rights to still fly over your land. You're probably not going to be able to stop them, right? Or you might say, well, Rob Rosa in the real estate class, he told me that I technically own to the center of the earth for my land. So I'm going to start digging a hole so that I can make a tunnel to China. Right? And so now it's probably going to be physically impossible, but in most towns and most cities around Connecticut anyways, I think once you start digging down, and I don't know the exact number, I think it might be a little bit different for each town, but you start digging down more than 10, 15 feet, you actually have to get some special permits. And if you decide that you want to do some mining and so forth, you have to get some special permits. You're not going to be able to just do whatever you want. So the first one for police, for governmental powers is P, police powers, right? And police powers, again, to protect the public health and safety and promote the general welfare. Now, here you are, you live in this town, right? And this town has these ordinances or laws or rules or regulations about what you can do and what you can't do. And you say, well, listen, I bought this land, I pay my taxes. Who gave this town the right to tell me what to do? So who gave them the right to tell you what to do? Who knows?
You did when you bought property in that town.
Well, kind of, yes, but who gave them the right ultimately? Where did it come from? To even impose taxes on you? What entity?
The municipality or the government?
What government?
The state government, the state does.
State government. So you need to know this term. It's called enabling acts. Enabling acts. And what enabling acts means is that the authority came from the state's police power, right? The state's authorities pass on to municipalities and counties through legislation. Now, in today's world, more than ever, I don't want to get into political debates because I just don't have time for the baloney, right? But in today's world, more than ever, who's pretty much telling us what we can and can't do every single day? The governor. They're telling you if you have to wear a mask or you don't have to wear a mask. If you can open up your bar or you can't open up your bar. If you can go sit inside a restaurant or you can't go sit inside a restaurant. So you see all that power that's coming from the governor? Well, that just shows you that this country, just as to remember this kind of stuff, it was actually started as a republic. It wasn't started as a democracy. We started as a republic where most of the power is to rely with the states, right? That's why it's called United States of America, right? United States. The states decided to join the US, you know, the federation or whatever you want to call it, the unity of all the states, right? So what they want you to know is that the original power came from the states, and the states gave that power to the municipalities through enabling acts. And that's what police powers are. And they can do everything with police power to enact environmental protection laws, zoning ordinances, building codes, how you can use the property, what's the maximum number of people you can have on the property, the size of the property, the location of the property, and so forth and so on. right? And again, do they have a lot of power? Of course. But also it has to be, or it should be, which is really important, you know, is that the power is not absolute and that it has to be uniform and fair to everyone, and it should not be discriminatory. So who has questions about police power? Okay, the next one in governmental power starts with an E. So what is E?
It's an eminent domain. And
Eminent
it's where they
domain.
could take. It's where they could take your land, your private land, and make it a public space, of course, for a compensation.
That's right. Very, very good. Now, the whole point with eminent domain is that they will trick you on the state exam. Okay, so they're going to ask you the question, the process by which the government exercises the right to take your land by either judicial or administrative proceedings is what? The process by which they decide to take, by which they can take your land, the government exercises this right. Is that eminent domain? No. That's condemnation. So when they use the word process, the process by which, like the whole, I guess what I'm trying to get to is you're going to know a lot of the answers to these state exam questions. And you might be a little anxious, you're a little excited, and you're like, oh yeah, I know the answer to that. And you kind of don't really take that extra second sometimes maybe to read it or absorb it, and you just answer it quick. And you could choose the wrong answer by mistake. So remember, this is a tricky one. When they say the process by which, that's called condemnation. And we're going to talk about that in a moment. But the term or the right of the government is called eminent domain. So do you see the difference between those two things? So eminent domain is the right of the government to do it, but condemnation is the process. So really, what does condemnation mean to you? And according to this in context with this, what does condemnation mean to you?
When they're actually taking your house and going through the process of appraising your house and how much they owe you.
Okay. So put it this way, can you live in a condemned house?
Like for the time being, maybe.
What does it mean for a home, let's just say a basic home? And it could be a beautiful home that's 2 years old or a year old, but it's condemned. Can you live in it? No, because what that means is that the town has taken away the CO, the certificate of occupancy, right? So the basic process, which I know there's a lot more involved, but I'm just going to give you the streamlined, right? Is that they figure out, oh, we need to build a highway through here. And guess what? We need to get rid of these 8 houses. Oops, this way. We need to get rid of these 8 houses of the highway going through here, and you are the 8th house. You know, 1, 2, 3, 4, 5, 7, 8. You're the 8th house. So we need to come and we're going to try to, we're the state, and we're going to say, okay, well, we figured your house was worth, you know, maybe it's a beautiful house. Maybe it was worth $425,000, but we really need this to connect these 2 highways, and there's nothing else we can do. And blah, 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 blah. And you're like, well, my house is worth a lot more than that, and I'm not going to sell it, and da, 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 da. Well, guess what? They're going to have public hearings. They're going to do this. They're going to do that. But most likely, you're probably going to have to give them your house. And they might, if you push it and you're smart enough and you get some good appraisers, you might be able to get a little bit more than 425, because I know somebody that works in the state who does that kind of thing. And he's told me, he's like, yeah, we'll try to work with the sellers. You know, we'll try to give them what they think is reasonable. But if it's unreasonable, we're not going to do it. We can't do it. We'll just give them the max. And it can get to the point where they say, listen, the most we can give you is $459 for your house. And in 9 months, you're going to have to move. And there's not going to be a whole lot that you can do about it besides going to the public hearings and thinking that you're going to call Channel 61 and Channel 3 News and you're going to get all this stuff going. And then guess what? They're still going to build this highway because you have all these people complaining from Hartford and New York City who need to get these two highways connected, right? So what they're going to do in 9 months, if you don't leave, they will have a sheriff physically remove you, and then technically they condemn the property. They take away its CO, its certificate of occupancy, so that no one can live in there anymore. And it doesn't mean it has to be an old beat up house. It could be a beautiful house that's fine, right? And so then from there, they move on to their way. So who's got questions about that so far, what we've gone through?
Rob, didn't they do that in New London some years back?
Mm-hmm.
Right, and it was a whole big, and everybody was trying to fight it in court.
Yeah,
right.
That was a huge issue and problem, and believe it, like this is a nationwide book, right? There are people in Hawaii who are probably using this book because this is like the nationwide one. And if you read in here, it talks about New London, right? And it talks about the concept of taking, because in the past, or most of the time, when the Fifth Amendment in the US Constitution says, nor shall private property be taken for public use without just compensation. So in the past, it was basically taken for public use. But what they actually did in New London is they got involved with some developer where it was going to be private and public, and it was going to be profit and nonprofit, right? And they said it was for economic development. And then the real estate market tanked and the running money ran out and all this stuff happened. And so you have these people that maybe they had in their family for generations, some nice little cottage, right? And that cottage was taken away and torn down, and now they have a gravel parking lot there. And those people who maybe their grandmother, great-grandmother, great-great-grandmother bought the property, they're never going to have a little cottage over there anymore. They're never going to have another waterfront property that was maybe in their life, in their family's life for 100 or 200 years, right? And so that it kind of like really, really backfired. Like they said, the city initially sought to avoid a $73 million subsidy from the state and attract private development. And then once, all kinds of things happened where they didn't have the money and so forth, everything went down, down, down. And even today, if you drive through that New London area, they probably did like 40% of what they said they were going to do. And there's some nice little parts to it, but there's still a lot of like empty lots. It's not really, it didn't turn out to be the huge, beautiful thing that it could have been or that they envisioned, right? So now we originally talked that you were the 8th house, right? We said through this highway that was going through here, right? I have a hard time, man, figuring this whole thing out with the camera, right? So the highway's going through there, and we said you were the 8th house. Boom, boom, boom. They need to take these 8 houses. But what if you were the 9th house? What if you were the 9th house where they only needed the first 8? And maybe you were in the middle of a beautiful neighborhood of these 20 houses and everything was nice. And now all of a sudden they take away those 8 houses, put a highway through there, and 100 feet from your house is now a highway. Do you think that will affect the value of your land or your property?
Yes, yeah. And you can do inverse condemnation.
Exactly. So the whole point with inverse condemnation is that you have to realize in most cases, it's almost impossible a lot of times to sue and win against the town or the state. That's why you're walking down a sidewalk and you trip on the sidewalk, or you're driving down the road and they got the big orange signs, construction, and they got all that writing on there. Maybe it says road closed or detour. And God forbid your muffler hits or your transmission hits the bottom of one of these sewer things and it gets torn off. And now it's going to cost you $4,000. Are you going to be able to sue the state to get the $4,000? It's going to be pretty hard to do that. But with inverse condemnation, right, it's basically terminology that says, hey, listen, you might have a chance that if you can prove that the value of your property was significantly diminished due to the construction of this highway or whatever it might be, that you can bring an action, a lawsuit to the state, or most likely the state, to be compensated for its value. Maybe it might be the federal government, maybe it might be the state, it could even be the town. And that in many cases, people are getting that money back. So who's got questions? And I know there was a lot there, but who's got questions on eminent domain? Anyone, is anything in particular you want to go over? So governmental powers, we talked, P was police power, E was eminent domain. What's the next one? P-E-T-T, taxation.
Taxation.
Right? Who's got questions on what taxes are? If you have questions about what taxes are, I don't know how well you're going to actually do on the state exam, right? You know, there's real property taxes, meaning on the homes. There's taxes on profits for individuals, for corporations, on the sales of property. There's special fees to finance special projects. I mean, I think we all have a good idea that taxes are pretty important, and if we don't pay them, we'll get liens on the property, and it will definitely negate the value of the property. And then the last one is for police powers, eminent domain, taxation. What's the last one?
Escheat.
Escheat. So what is escheat?
Escheat is when someone dies intestate or without a will or no heirs to it, or so.
Okay. So they
Yeah.
own property, right? And then they pass away intestate, that means without a will, and they have no heirs that can be identified. Not these heirs, right? No heirs. I say it the wrong way, I think, right? But anyways, owner dies, leaving no heirs, and there is no will or living trust instrument to direct how the real estate is to be distributed. So what happens to that real estate?
The government acquires it.
What government?
The state.
The state. And in Connecticut, after how many years does that happen? So there's the wonderful red book question. In Connecticut, how many years does that happen? It's cheat. So you'll need to know that.
Is it 2 years?
That would be awfully quick. Sounds like a good guess, though. I'm not gonna judge you on it. But the whole point is 20 years. 20 years. So, I mean, I don't know if I can exactly identify a particular property this happened to, but like one of the ways an attorney explained it to me years ago was he was like, hey, and I kind of remember this. Hey, have you ever seen one of those houses where all of a sudden it was like just painted white and it was even boarded up and the wood was painted white? You ever remember once in a while, and when we were younger, like I think with this whole ancestry, internet and everything, it's probably that they can find heirs a lot easier now. But back in the day, every now and then, I'd see a house that was all boarded up and it was all painted white, right? And it might be like that for a few years, and then all of a sudden they demolish it, and now it's just land. That's usually, you know, he was explaining to me, that's usually one of those houses where, you know, they can't find the heirs for it, if, you know, and then it becomes a safety hazard after a few years.
Well, they do that as well if they have heirs, but the heirs don't want to do anything with it because there's either a tax lien or something on it, and nobody wants to claim it because then they have to pay off the taxes. So they board it up for that. That happened to, I know a few people whose families went through that.
Yep. So that's exactly what we're talking about. So that would be in Connecticut, it's 20 years. So this class reminds me and that how irresponsible I am being, because we know, or hopefully you're going to know now, after this class, you can go onto the you can do a Google search, state of Connecticut unclaimed assets or unclaimed property. And there's a website. And you could put your name in there, or somebody from your family, and you put your name in there, And you'll see, you might find out from an old account or an old savings account, checking account, brokerage account, something somewhere, that maybe there's unclaimed property that you can claim. And I actually have something out there for a couple grand that I need to sit down for an hour, put the paperwork together, take the photocopies, do this, do that, and put it in the mail. And I just never have done it. And if I do it, maybe in 6 weeks, I'll get like a check for like $2,000 and something, because I guess when I was younger, I opened up some kind of account somewhere and forgot about it, but it's still there under my name. So there's an example to you. I might have just made you a lot of money, and I'm not even going to take 10% from you, right?
But with Escheat, isn't it, you said that it's someone dying and leaving no heirs, or no heirs that were known. So how could you, for example, if this person did have family?
Well, what would happen, just think about it this way. Like, they have to make it a public record. So maybe they put it unclaimed property, they put it on this website. And, you know, they know the person doesn't have any brothers or sisters, the basics, but maybe the person has some, you know, who knows, I'm just making it up, some second cousin somewhere. And now the second cousin looks it up and says, oh, Uncle Rocco used to own, he passed away, he used to own the house, nobody's made a claim on it. And then they think about it, wow, I think I'm the only one that's left that's related to him.
So you would actually Google search dead relatives instead of yourself.
I guess you could do that, right? Yeah. I guess you could do that. I'm just, you know, but the point is, things get weirder than that, right? You know, things get weirder than that. I mean, you could, I'm not, you know, that feels a little weird, I don't know. But I guess you could do that.
Yeah.
Right? But I think things were a lot harder to check for heirs and you know, descendants and all that good stuff back in the day, before we had all this great stuff going on with the internet. But anyways, the whole thing is, you need to know escheat occurs when the state takes control of a property after the owner dies, leaving no will or lawful heirs. And in the state of Connecticut, that's 20 years. All right. So who's got questions on this unit? On Friday, right, we talked about, this is the unit of interest in real estate. We talked about freehold estates lasting for an indeterminable amount of time. Fee simple, the highest estate recognized by law. Fee simple defeasible is an estate qualified because it is subject to the occurrence or non-occurrence of a specified event. A life estate based on the life of another or someone else, which is called per autre v, right? An encumbrance, which is a claim, charge, or liability that attaches to real estate. A lien, which is a charge against the property that provides security for a debt or obligation of the property owner. We talked about covenants, conditions, and restrictions, which are private limitations on the use of the land. We talked about easements, the right to use the land of another. We talked about an easement appurtenant, which is said to run with the land when the title is transferred. Dominant tenements benefit from that easement, which runs over the servient tenement, because the servient tenement is serving the dominant tenement. The servient tenement is letting someone drive over their land, let's just say, to get to someone else's land. We discussed an easement in gross, which is an individual or company's right to use another person's land or another individual or entity's land. An easement by necessity arises when land has no access to a street or public use, so the land is not landlocked in the middle of other pieces. An easement by prescription, right? Easement by prescription, which is basically using another land for a period required by law, must be continuous, non-exclusive, visible, open, and notorious in order to make a claim that you want to take that land. So in Connecticut, right, how many years do you have to prove in order to do adverse possession? So you need to know that number. Who knows how many years?
5?
15.
15.
15 years for adverse possession. Okay. We started the class talking about the ways in which an easement can be terminated when it no longer exists, when the owner of either the dominant or servient tenement becomes the owner of both, when the owner of a dominant tenement releases the right of easement to the owner. We talked about a license, which is a personal privilege or a right to enter the land for a specific purpose. An encroachment, we discussed about when all or part of a structure illegally intrudes on the land of another beyond the building lines. So somebody puts a shed a couple feet over, a garage, a fence, right? We discussed the lis pendens, giving notice of litigation in progress that may affect the title to the property. And then lastly, the wonderful world of the government powers. So what's the acronym for that? Who remembers?
Pete.
Pete. And we have police power, which is the state's authority that they pass down to municipalities. And what term do we need to remember for that? Begins with an E.
Enabling acts.
Eminent.
Enabling acts, right? And then we talked about eminent domain, right? The government's right to acquire privately owned real estate for public or economically, supposedly beneficial use through what? What's the process by which they do eminent domain?
Condemnation.
Condemnation. Then we discussed taxes, a charge on the real estate to raise funds. And then we discussed escheat, and escheat, where the state takes control of the property after no will or no heirs. And how many years is that?
20.
20, right? And then we talked about the concept of taking, right? Where the Fifth Amendment to the U.S. Constitution requires that the owner be given just compensation if they take their land or take adjacent land, which affects the value of their property, and that's called inverse condemnation. So before we do the quiz, what questions do you have on this unit? None? All right, let's get ready. Okay, so let me see here. Okay, now we're going back to the quiz. So let's see how you did. So number 1, an elderly man left the family home to his second wife with the provision that when she dies, the home goes to a son by his first wife. The second wife owns a bundle of rights but does not own the right to what?
Sell the property.
Okay, so you see how he says he left it to the second wife with the provision that when she dies, the home goes to a son by his first wife. So the wife might own, the second wife owns the bundle of rights, but she does not own the right to will it, because you see, he says he put it in there that it goes to a son. So the second wife owns the bundle of rights, but does not own the right to will it. So does that make sense to everyone? All right, so number 1 is A is in apple. 2, every
Like,
day.
she wouldn't be able to sell it, or she wouldn't be able to sell it though, right? I'm confused.
She probably would not be able to sell it. But the whole point is what they want. Well, see, it doesn't necessarily, they're just saying that she maybe can sell it, but if she was to sell it, it might have to have a provision in there that they understand when this woman dies, the home is going to go to the son. That's the whole point. Is so who knows if she can like lease it? Who knows if she can like sell it without the right to will it? You know, because remember, we're used to that when somebody owns a property, they have all the bundle of legal rights. Well, this unit, especially the first few pages, which we didn't go over today, we went over in the last class, is all about owning different interests. So you know, I guess technically maybe she can sell it, but not give the right to will it, you know, because ultimately that right is going to, the property is going to go to the son when this woman dies. You see what I'm saying? It gets a little tricky. And that's why we talk about different interests. Like, again, can I sell you a piece of property or a nice, beautiful home and tell you, okay, I'm going to give it to you at a great price. I'm going to give it to you at 50% of what it's worth. But guess what? Every Friday night, I like to come over there and smoke cigars and have some whiskey and let the kids swim in the pool. And then the week before Christmas and the week between Christmas and New Year's, we're going to come over there. We're going to live there. We're going to have, you know, take over the 3 bedrooms and do this and, you know, and be able to enjoy it. And we're going to do this and this and this. So you see, it depends on the bundle of legal rights and all the different ways in which people can have actual rights to the property. That's why it gets tricky. All right, so number 2, every workday for the past 20 years, a woman has parked her car in a specific place in the nearby parking garage. Today, she receives a notice that the garage will be replaced by an office building. Can they do this to her after all the years she parked there?
See?
You got it. C is in Charlie. She only had a license, right? She only could enter the property for a specific purpose, and that's the reason why. So C, it would be C where she had a license. Number 3, a man conveyed a 1-acre parcel of land to a preschool. In the deed, the man stated that the property was to be used only as a playground. The man reserved a right of re-entry. What kind of estate has the man granted? What do you like?
B.
B, right? So think about it. There's a limitation. It can only be used as a playground. There's a limitation there. And they reserve the right of re-entry, saying that, listen, if it was used as something else, you know, we're going to take the property back, right? Condition, subject to a condition subsequent. If at some point in the future the land is not used as a playground, the man or his heirs may exercise the right of re-entry. Make sense? So that's just one of the ways that you can have different interests in land. Number 4, a man files a notice in the public record of pending litigation affecting the title to a property. This notice reflects which of these?
D.
D.
B.
Right? So there's going to be a public notice that's going to be put basically in the public record. And it's going to affect the title, and people who want to make claims to the property or transfer the property or whatever are going to know about this. So 4 is D as in dog. Number 5, a property owner gave land to a school so long as the land is used only for academic and recreational purposes. The ownership interest granted here is called what? What do you like?
D.
Okay. So long as, right? That's fee simple determinable. So long as. So basically, again, it's kind of similar to number 3, right? This one's called fee simple determinable, where when they use that language, so long as or while, right? So long as or while, then the person who's receiving that land, they're going to have the full bundle of legal rights, except there might be some special features or limitations there that they have to abide by. Otherwise, you know, basically the original owner can get the property back. So long as or while, you know, while or during. right, then that's fee simple defeasible. Any questions on that? All right. Number 6, if the government acquires privately owned real estate through a condemnation suit, it is exercising its power of what?
C.
See?
D.
See,
All right. So the right of the state to acquire property for public use is called what? Eminent
Oh,
domain,
C.
right?
C. Yeah, C.
But the court action is called, right, condemnation. So that's the whole point. See, that's court action or the process. Court action or process of
Who's that?
eminent domain.
Oh, hi.
Okay. All right. Number 7. I guess someone's getting an exciting visitor, right? Number 7. A man owned 2 acres of land. He sold 1 acre to a woman and
Sorry.
reserved an easement appurtenant for entrance and exit over her acre to reach the public road. So the woman's land is what?
B.
B.
B as in boy.
B, right? The servient tenement, which is 7B. All right. And so remember, you know, here's 1 acre of land and here's the other acre of land. Okay. And so if I'm driving and I need to drive over this person's land to get over to this acre, see, so here's the road, right? And I need to drive over this person's land, right? Well, this person is the servient. Right? And this one is the what? Dominant tenement. So does that make sense? Because I'm driving over A to get to B. All right. So 7 is B as in boy. Number 8, a man owns a large undeveloped parcel of land on the side of a hill. The property borders a road on the lower edge. The owner sells the lower portion of the property to a woman and she builds a home on it. Several years later, the owner sells the upper portion of the property to another man. This man's property does not border any road. For this man to gain access to the road, he must claim by implication of law an easement of what?
By necessity.
A.
A, by necessity. Why?
He needs to be able to get out of his property.
Yeah, there needs to be legal access to the second man's property. Make sense?
Yeah, I apologize for that disruption.
No, that's okay. That's okay. We know things happen, you know.
Mhm.
All right, number 9. If the dominant estate merges with the servient estate, which of these is true?
C.
B.
Okay, so here we'll go back up to number 7,
C.
right? So I come over here and I buy I buy both properties, right? And I make it one big property. What happens to the easement? It goes away,
cancels it
right?
out.
It goes away. That's how that works. So number 9 would be C. If you merge or you becomes one, it's basically terminated. The red, that's how that works, right? Does that make sense to everyone? Who's got questions on that? Anyone? All right. Let's keep rocking and rolling. Number 10, the homestead exemption in a town is $15,000. 4 years ago, a man purchased a home for $58,000 and then experienced hard times. At a court-ordered sale, the man's property is purchased for $60 grand. If the man has an outstanding mortgage balance of $35 grand and credit card debts amounting to $24,360, how much is protected by the homestead exemption? Man, if somebody got this right, I will be pretty
D.
impressed. So you like D? Anyone else?
What A?
You like A?
I
put
I
C.
Okay. So let's think about it this way. Okay. How much is the homestead exemption? $15,000, right? So the property is sold for how much? $60,000. Okay. So the property is sold for $60,000. Okay. Now the mortgage that has to be paid is what? $35,000. For the mortgage. Okay. Sold for $60,000. Now there's how much left for the credit card debt?
24,360.
Well, technically, okay, so I should take this step back. Let's do one more thing. You have 15,000 reserved.
Mm-hmm.
So technically, if you add those two together, how much is left?
It's
$10,000.
$10,000 for the credit card debt. So technically, again, there's only 10,000 left for the credit card debt. I know this is tricky, right? There's only 10,000 left for the credit card debt, but left over. But because it's more than that, it technically just goes back to this. Basically, how much is protected, right? $15,000.
Yay. Guessed it, but okay.
So this isn't really like looking at a lot of math as far as doing calculations. It's more like understanding it that, hey, you know, there's really only $10,000 left for the credit card debt, but you're already protected by 15. So because it's more than, you know, how much you owe, because you owe debts more than that amount. Does that make sense? That's the problem that you have to understand. You owe debts more than that amount. So regardless, you're still protected by the 15,000. Kind of a hard one, but you have to kind of understand, okay, no matter what, because you owe more than the 15,000, you're still protected by it. Does that make sense to everyone? I know it's pretty tricky, especially if it's the first time you're actually doing something like that. In some states, a husband cannot sell his property unless his wife also signs the deed. The wife's interest is called what?
C.
C.
So,
Yes, in Charlie.
okay, so basically when we talk about the wife's rights, we're talking about because the husband's either passes away or something happens to the husband, right? So those are the wife's rights, right? Is called dower, D, your dower for wife.
Yeah.
I thought it was C.
That's
I thought
right.
curtsy is how you girl.
Yeah, me too.
Well,
Yeah, because
put
that's
it
how we
this way.
remembered it.
This is the way I explained to you before. The wife, when she passes away, she does her final curtsy. So that gives the husband rights.
Oh.
Widower, widower, and widow, basically.
So you can think about it that way. A widower is like the wife is left over, the wife is still living.
Mhm.
You know, the wife is still living, she's the widower. Dower. But yeah, so 11 is going to be D as in dog. Number 12. The state's authority to enact legislation to protect the public is passed through to municipalities and counties through what?
B.
B.
B, you got it, enabling acts. All right. 13, the state requires, oops, let me just move this up. All right. The state requires enough land to build a 4-lane highway. For the state to acquire the needed land, the state must do all of these except. What do you like? What do they not have to do?
C.
You
D.
like anybody else? D. So they don't have to say, oh, you paid $1 million for this land, but now it's only worth $750. So we're going to still give you $1 million. No, they're not going to care about how much you paid for it. They're going to try to reimburse you for not how much you paid for it, but what they think is the market value. So with everything else, it's a timing game, because if they come to you, you know, at a time when your property is worth less than what you paid for it, there might be a bigger issue for you. There might be, you know, more issues that come up. So for 13 is D as in dog. 14, a woman died in a nursing home. She had outlived all of her heirs and had not written a will. What happens to her $250,000 estate?
A.
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 And in Connecticut, how many years?
20.
20.
I.
Connecticut is 20 years for Escheat. All right. Number 15. Which of these is defined as a claim,
A.
charge, or liability?
A.
A.
You sure?
Lien.
All right.
That
So,
attaches to real estate.
what's that?
You said 15 is defined as a claim, charge, or liability that attaches to real estate.
That's right. So what do you like?
A.
Everyone like A? Anybody like anything different? Anyone? Anyone? So here's the whole thing where it starts to get a little bit.
Oh, I do.
D.
C.
Encumbrance.
That's right. So why is it D? Because remember, you have
Ooh,
under
lien is a
like
part
the
of
umbrella,
encumbrance.
right? The umbrella. This is encumbrance.
Mm-hmm.
And under there is where we have liens and easements and encroachments and restrictions, CC&Rs, right? So because are all liens are all, well, let me say this the right way. I just want to say it the right way. Remember, all these are all encumbrances, right? And so that's basically what we're talking about, because there could be, like, it is an easement a claim necessarily against the property? No, it's more like a liability, an easement, where somebody got a piece of, is able to go across your land. It's not necessarily a claim. It's more like a liability. Or like is a deed restriction, where a deed restriction right might be like no clotheslines, right? Is that going to be necessarily a charge against your, or a charge that attaches to real estate?
No.
No, but it could be a liability, right? Let's say for So that's why, anyways, encumbrance is the overall umbrella. It could be a claim, could be a charge, could be a liability that attaches to the real estate. Make sense? I know it gets tricky. All right, number 16. Which of these must exist for an impertinent easement to exist?
A.
All right, A. You have to have two different parcels and two different owners. Because if it was one owner, right, that would probably terminate it. If it was a landlocked property, like let's say letter C, that would be what's called a what? Who would know what this would be called? Landlocked property. What kind of easement is that?
Impertinent easement.
Thank you. That's the one. Thank you.
No, a pertinent easement is A.
Easement by necessity.
That's right. That would be an easement by necessity because you can't have, you're not supposed to have landlocked land. Right? And then what kind of easement would this be?
Which one?
D.
Prescription.
That's right. Easement by prescription. All right. So that's why 16 is A. 17. What are deed restrictions?
C.
C. Right? No clotheslines. Can't park your boat in the driveway in the front of the house. Can't live in the garage. You know, they're basically, deed restrictions are private agreements written into the deed and privately enforced, right? If it was a public thing, it would be something where it's breaking zoning and building codes. And sometimes they overlap, but technically deed restrictions are private restrictions. Does anybody have questions about that? All right. Number 18. The electric company has the right to extend its wires over 50 parcels of land. What right does the electric company have?
C.
D.
C.
Okay. Well, easement by prescription has to be notorious.
D. I don't.
Yeah, it is D, right? So remember, utilities, right? These are mostly utilities. Now, there could be such a thing as a personal easement in gross. There is such a thing as a personal easement in gross. But a lot of times what we're talking about is, oh my gosh, utilities. We're talking about utilities or a personal easement in gross in which there's one party that's using another party's land, right? And basically, what else do I want to say about it? So there's no like dominant tenement. There's only servient tenements. So here's like, for instance, the piece of land, and here is a railroad that's going through it. You see how there's no dominant tenement?
Yeah.
Like there's not another parcel of land which the person owns it, two different owners, and going from one owner to another. It's just like the utility is running through it. So there's no dominant tenement. There's technically only a servient tenement. There's only this land, lot A, that's serving the railroad tracks. You know, and then it could be, oh, well, this land after there, that's lot B, and this land above there was lot Z, you know, and so forth. But there's no servient and then dominant. There's just servient. There's no dominant tenements. Does that make sense to you?
Yes.
All right. So you got to kind of remember. Now, remember, one of the tricky things is, and this we talked about last week, is a personal easement in gross. When does that terminate? Personal. When does that terminate? Personal easement in gross terminates when?
When you sell or when you die?
When the person dies. So here's the example that we even talked about. Somebody says, okay, you go to them because you have a very sloped house, parcel of land. It's very sloped, but you really always wanted this little workshop garage to be put on your land. And you know that if you put it there, it's going to be like 4 or 5 feet under your neighbor's land. And he's this old guy that you've been close with for 20 years. And you're like, listen, I really would like to put this little workshop there and blah, 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 blah. And you're like, isn't there any way you'll do it? And he's like, I don't know. And then he comes back to you and he says, listen, I'll let you put the workshop there. We'll write it up in the deed. But upon my death, I want that workshop to be removed because my daughter and you really don't get along and she's going to want to sell this land. And I want her to be able to sell this land with no problems, with no issues that we have to be concerned about. So it's going to be written in the deed that upon my death, you no longer have this easement. You no longer have this personal easement in gross. So does that make sense? That usually goes like that. So most of the time it's utilities, an easement in gross, but it could be a personal easement in gross. All right. Number 19. For as long as anyone can remember, neighbor families have used a footpath to get to the river. Recently, the current owner erected a fence across the path. Which of these easements might the neighbors claim, which would require him to remove the fence?
B.
This is where it gets tricky, right? To remove the fence could be what? B, an easement by prescription. Because with an easement by prescription, right, what could happen is that you can actually, in the state of Connecticut, if it's, and again, what does it have to be? Who remembers easement by prescription? What does that have to be? Anyone? Has to be basically non-exclusive, visible, open, notorious, that you were walking down this footpath. You're not being sneaky. You just walk by this footpath every day. It has to be continuous, every other day and so forth. And in Connecticut, how many years in order to make the claim? How many years? 15. So, and you can also use the term tacking if you wanted to. So what's tacking? Who remembers what's tacking? That if the previous owners did it before you, maybe you've only been doing it for 3 years, but you can bring to court the previous people who are doing it for 12 or 13 or 14 years, right? So you bring them to court and you can help them state your case in order to get an easement by prescription for, basically adverse possession. To take the property. Make sense? All right. And then number 20, the holder of a life estate is called a what?
B.
Life tenant. B.
Life tenant. You got it. All right. And basically, remember, we're not talking that they're a tenant like a renter. Not like a renter. We're basically saying that they have the rights of ownership and can benefit from the possession and the ordinary use of the property. Just like a tenant can use the property, that's what we're talking about. Not that they actually pay rent. Okay? So that's what we have for this wonderful world of unit number 3, interest in real estate.
Yeah.
Hopefully you did well. Remember, each question is 5 points is 5 points. So if you got more than 4 wrong, right, you got less than an 80%, you need to go back to this unit and study, or you need to be able to ask me questions, come back, and you're more than welcome to ask me more questions. So I hope you enjoyed this quiz.